Hello, hello, hello. People are coming in. More and more people are coming. We're waiting a couple of more minutes for everyone to sit down and grab a snack and enjoy the show. Cool. So many people, so exciting. Also the note already that we're recording this. So this will be available to everyone at some point. Cool. Alrighty, well, let's get started with this. Hi, everyone. It is an incredible honor, literally, to be here amongst these women here on the panel that you can see for this morning's event on No Systemic Change Without Legal Change, Feminist Engagements with International Law. I'm Kristina, one of the co-founders and co-directors of the Center for Feminist Foreign Policy. We are a research, advocacy, and consulting organization promoting a feminist approach in foreign and security policy, meaning we are about smashing patriarchy within foreign and security policy. Because ultimately, because of how society has been shaped and been working, there will not be any sustainable peace anywhere without feminism and feminist interventions. Tonight's event, we've been organizing together with the Global Justice Center, and as a way of introduction, the Global Justice Center was founded in 2005 to fill a critical need in the international human rights field. As an international human rights and humanitarian law organization, it works for peace, justice, and security by enforcing international laws that protect human rights and promote gender equality. And we also have the director here with us this evening, Akila, who I'll present in a second as well. Right, so as you can see, this event, literally, we coined it internally as the panel of extraordinary women, which, if you don't know yet, you'll understand in a second, because we have with us this evening, Chinkin, and I'm just scrolling here to find all the right bios at the right time. Christine from the London School of Economics. Christine is Professor of International Law and Professorial Research Fellow and founding director of the Center of Women, Peace and Security at LSE. She's a barrister, a member of Matrix Chambers. Together with Charles Worth, she won the American Society of International Law 2005 Gola T. Butcher Medal for outstanding contributions to the development or effective realization of international human rights law. She's currently a member of the Kosovo Human Rights Advisory Panel and was scientific advisor to the Council of Europe's Committee for the Drafting of the Convention on Preventing and Combating Violence Against Women and Domestic Violence, the Istanbul Convention. Kristina, it's such an honor to have you here. We also have with us Professor Beth Van Schaack from the Stanford Law School, and Beth is the Leah Kaplan Visiting Professor of Human Rights at Stanford Law School. She formerly served as Deputy to the Ambassador at Large for War Crimes Issues in the Office of Global Criminal Justice of the US Department of State. She has been a member of the US Department of State's Advisory Council on International Law and served on the United States Interagency Delegation to the International Criminal Court Review Conference in Kampala, Uganda. She also has served as an acting executive director of the Center for Justice and Accountability and as a law clerk with the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia. And we also have with us Akila Radhakrishnan from the Global Justice Center. And Akila is the president of the Global Justice Center, where she leads its work to achieve gender equality and human rights, and has led the development of groundbreaking legal work on both abortion access and conflict and the role that gender plays in genocide. Her unique expertise as a feminist international lawyer is sought by policymakers, academics, media, and grassroots actors around the world. She has briefed the United Nations Security Council and the UK and European parliaments, and regularly advises governments and multilateral institutions on issues of gender equality and human rights. Such an honor to have you all here with us this evening and morning. So what we'll do now is we'll do roughly 25-30 minutes of questions that I have for you, and then we'll open for Q&A, and everyone in the audience, you can already start posting your questions whilst you're talking in the Q&A box, and we'll have them, hopefully all of them responded to later on. So so this evening's event, I mean, I know you usually, what you are doing, you are leading the kind of the rethinking and the challenging the status quo of international law all the time. That is your work. And this evening, this event now, this morning, we really want to use to inspire people and to give people an idea of what's wrong with international law, like why international law, such as all institutions and creations within a patriarchal society, why does it have problems and why does it need rethinking? So I might ask a couple of more basic questions that you might be used in your daily intellectual work. And yeah, so we'll get started. So Christine, before we opened to the audience, Akila rightly said that, Christine, you've wrote everything that's out there on feminist engagements with international law. And in a very famous article you once co-authored, that also everyone in that area knows, it reads that feminist approaches to international law means reinterpreting and reformulating substantive law so that it more adequately reflects the experiences of all people, and an alternative method of practicing, talking about, and learning the law. Feminist method must be concerned with examining the fundamentals of the legal persuasion, the language it uses, the organization of legal materials, and so forth. So, Christine, that was in the 90s. Some time has gone by. Would you please first tell us why you started doing this work? Why have you gotten interested in like questioning the law, and how did this article come about, and what has happened since, like your journey to feminist critique?
Wow, 30 years in 2 minutes. First of all, thank you very much for inviting us. This is a great event. And I really would like to say, yeah, we wrote that article back in 91, I think it was published. There's been some really great feminist international approaches to international law written by many, many scholars since. And so I don't think I can lay any claim at all to being the first, having written most of it, some great stuff, and really taken it a lot further than we did back in 1991. Why did we do it at that point? I think it was at that stage, there was within the academy a great deal of attention being given to feminist analysis of law in general. And Hilary and I were both in, well, the three of us were all in Australian law school, Shelley and I in Sydney, Hilary in Melbourne. Very strong at that point. There were discussions around the curriculum, there were discussions around how law should be taught within the law school, concerns that too often any mention at all, and I think at this stage it very much was seeing feminism as being about women. I presume we'll come to the issue of gender more later. Too often it was, if women were mentioned at all, it was an add-on, or it was, in criminal law there'd be a class on rape, that sort of thing. Issues around women in the law were still very marginal, and at the same time there was this great deal of thinking about pedagogy, about materials, about the curriculum. And I think there was, of the three of us, I mean, we were talking about this actually quite recently, and we all assumed that this was something that really did not touch international law. That international law is the law that operates between States. States are impermeable to feminist influences in their international guise, and that simply feminism and international law was a oxymoron, if you like, or just a misnomer. Then they, I won't go back into the history of it, but there was an opportunity of a conference in Canberra at the time, and three of us sat there saying, well, if there was any way in which feminism could be relevant to progressive reform in international law, what would it look like? And we began sort of just making notes, bullet points and so on. And at about the same time, there was a call for papers at this conference. So we said, okay, let's see. And somewhat to our amazement, the organizer of the conference said, yeah, great idea. And then we thought, oh dear, now what do we do? And sort of really began drawing upon very much feminist approaches to domestic legal systems. And at the same time, there was quite a lot of work going on in international relations, feminism and international relations. And so drawing upon that work. And it also coincided with the activism. And I look here, particularly towards Akila, that the Nairobi conference in 1985, the 1975-1985 was the decade of women. The Nairobi conference, I think it was really absolutely instrumental in bringing together women from a real global. It was when we could really start talking about a global social feminist movement. And at the Nairobi conference, issues were raised around poverty, social justice, violence, issues that concerned feminists globally, and that international law is supposedly regulating and there to address. And so we drew on all those various sources. I better try and keep this a bit shorter. As I said, 30 years and 5 minutes. So what's happened since the article was received? It's, I don't know, we fluctuate. Yes, there has clearly been progress, but I think that there's been very little progress in really challenging the structures, substances, and basis of international law. Where there has been progress has been in specialist regimes of international law. For those of you who aren't international lawyers, there are multiple regimes: international human rights law, international criminal law, international environmental law, international humanity, I could go on. And where there are issues evidently relevant to women within those regimes, there has been some considerable progress. But that progress has been, and again, I'll look at you, Beth, I'm sure you've got more to say about this, at very often at the level of saying, let's ensure that crimes of sexual violence are included in the latest canon of international criminal law. Let's ensure that women's human rights are understood as including violence against women, rather than saying, let's look at the structures that underpin those different regimes. And more importantly, still in the terms of international law, the building blocks of international law itself, those things that say international criminal law, international human rights law, etc., are all part of international law. Those building blocks, the sources of international law, treaty interpretation, rules relating to jurisdiction, rules relating to sovereignty, rules relating to state responsibility, those fundamental basic structures of international law, those have been barely touched, I would say, in many ways. And so, yes, we have areas that we can all point to, and they are important, and I think we should celebrate them. But that does not mean that international law as an overall discipline has been has integrated notions of feminism. That's a bit of a long answer.
But still impressed. That was 30 years kind of in 6 minutes. Thank you, Christine. And yes, I would like to hand over to Beth and also Akila. If you could please, first also please briefly kind of tell the personal story, why you got into international law and a feminist perspective, but then also respond to what Christine said, like why are these gaps still there? What does it have to do with patriarchy and the domination of those who are still making law?
Yeah, well, thank you, everyone. It's great to be here, and it's a real honor to serve on this panel with all of you and to be introduced to the great work of the center. Kristina, you've really identified, I think, a gap in terms of thinking about feminist approaches to foreign policy and international law. And I'm so thrilled that you've filled that with your great center, and I look forward to being involved going forward. I also really want to commend Christine and the article. I threw the link into the chat. I hope you can find it through a library or such. It's incredibly relevant still, even this many decades later. And I say that first as a compliment to Christine and her co-authors for their prescience and their groundbreaking thinking on what a feminist approach to international law could look like. But I also say that in many respects as a lament that we still have so far to go. There's still so much that you envisioned that has not yet been realized. And I think you put your finger on it exactly, that we've injected and we've recognized women as victims primarily, and we've surfaced that reality, which has been invisible for so long. And many of these regimes, as you mentioned, have finally recognized the role of women and have created international crimes. For example, we had the International Criminal Court has released some very groundbreaking verdicts, both on intergroup harm as a war crime. So the harm to women militia members by the Lord's Resistance Army and other armed groups can now be prosecuted as a crime against humanity or as a war crime. We've had in the Angwen case that recently came down the recognition of forced impregnation as a war crime and a crime against humanity, and Akila's organization has done a lot of work in this area, building this out. We've also seen some real strides in the direction that I think the article was pushing on in terms of bringing women as the makers of international law. So women now more wield power as representatives in national state houses, as diplomats who are operating in multilateral fora, as presidents and even prime ministers, that we have the highest rates of leadership now than we ever have before in human history. So women are increasingly participating in the making of international law, but we haven't yet changed the fundamental bases. They're still the same structures, sources of international law, treaty, et cetera. But by injecting women into those processes, I think we're creating avenues for a more feminist approach to the creation of international law. We also see women increasingly serving as judges in international bodies, organizations, courts, tribunals, et cetera, but we still haven't come anywhere near to parity in terms of having women operating at these leadership roles where decisions about what direction international law is going to take. For the non-law students and lawyers in the group, international law has historically been made by states, for states, and to advance state interests. That's the reality of the history of the field. And so much of what we've been trying to do through the human rights realm, et cetera, is to think about the individual and groups and their communities as the subjects of international law and enable them to have a voice in the creation of international law. Because ultimately the relations between states and the relations of states to their citizens are impacting upon these individuals, and they should have a say in what the rules are that are governing those relationships. Another area where we've seen great strides is international law used to deal with relations between states, and now we have the whole human rights realm that governs the relationship between the state and their citizens, nationals, subjects, et cetera. Interesting that the word subject still gets used, particularly in the UK context. But now we're seeing also responsibility and obligations placed upon states to better police the private sector to protect individuals. We have a lot of work to go here, but states can be held liable for failing to protect women, for example, from intimate violence or from violence through gangs or terrorist violence. Communities that are suffering from these, states can be held liable not only for their own actions and the actions of their agents and instrumentalities, but also of private actors if the state is aware of the risks and has not created systems in place to be preventative and protective and then to offer justice after the fact. We also have, as Christine and others have mentioned, a good normative development. We now have a number of treaties that address women, sexual minorities, LGBTQI persons, et cetera, indigenous people, other marginalized groups. Not to the degree we need, but that normative development is happening. We're falling short still at the level of implementation and enforcement. So while Cedaw, which is the Convention on the Elimination of Discrimination Against Women, has been pretty widely ratified, my country being a notable exception to that, many states have not subjected themselves to scrutiny under Cedaw. They don't allow individual complaints to be brought by women who have experienced violations of Cedaw. We have good regional treaties, but they don't have strong enforcement mechanisms. So we have this normative articulation without enforcement. And that's another area where I think we need to see improvement. So I'll pause there. I really look forward to the discussion, but I think we've started to put our finger on where we've seen progress and where we have a lot of work still to be done.
Thank you, Beth. But one sentence on your personal journey. Why are you doing what you're doing?
Sorry. So in law school, I was originally thinking about a career in public health after I graduated undergraduate. I had done a lot of work on public health and women's issues in the health realm. And I spent a year in East Africa looking at women's health issues and was really struck by the fact that, and this gets back to Kristine's point, so much of women's ability to have an autonomous life, to make autonomous choices about their own health, was impacted upon by the legal framework in which they were operating, which discriminated against women on all fronts, owning property, in the family, when it came to work and being paid equal pay for equal work, et cetera. So the whole legal framework was conspiring essentially against women. And so that ultimately inspired me to go to law school rather than public health school, because I felt like I needed to understand the tools of the law and how those tools could be amended to better enable and empower women and to deal with dismantling some of the structural barriers that were preventing women from making good choices for themselves, autonomous choices for themselves. And so in law school, I did a lot of work in the clinic. And then my first job was actually at the prosecutor's office at the ICTY, the Yugoslavia Tribunal. And we had a terrific woman there, Patty Sellers, who had the gender brief, basically. And on the one hand, you could say, well, wait a minute, that's weird. Like, it was ghetto, it was this like one person, but she was such a remarkable person that she made sure that gender issues, violence against women, permeated all of the work of the Office of the Prosecutor. And it speaks to that importance of having women in high places, women who have the ability to set policy and make decisions. And so she ensured that every case that had the ability to include gender violence in the indictment included gender violence in the indictment. And that really created a whole field of gender-based violence, sexual violence in conflict, and then resulted ultimately in the ICC issuing the two groundbreaking rulings that I mentioned. And so it was really going to the ICTY, seeing someone like Patty at work, and then seeing how the law could be used to protect women and to offer justice. So that was sort of my pathway.
Impressive. Thank you so much for sharing, Beth. And Akila, so you are leading the Global Justice Center, an organization founded in 2005. So when Kristine, when the group wrote that article, and then like a bit more than 10 years later, the founder of your organization, was she like, okay, that is not enough, it's not progressing fast enough, we need to start this organization? And how have you been, what has your work been, and with regards to the improvements, but also the failures or the lack of improvement that we still have? Where is the Global Justice Center operating, and what's also your personal story?
There we go. I clicked all the wrong buttons. A year and a half into Zoom, and I'm still having difficulty unmuting myself. Thank you again, Kristina. It's been a pleasure to co-organize this, and to Kristina and Beth, it's always an honor. And as I was saying before we started, as I was prepping for this yesterday, Kristine's work remains seminal in this space. It's been a pleasure to actually get to work with Kristine over the years as well. But I think, as a starting point, I'll say, and this is also goes to the history of GJC, oftentimes this is the story of women. This is the story of individual women and the way they've taken their personal experiences, their own commitment to feminism, and found the pathways through the law to shift and help have these conversations in the first place. It has been, the structure of international laws we've been talking about was largely written not only on the basis of states, but largely on the basis of those who represented the states in making it, which was almost entirely men. And so the structure is one where I think what we've seen is this retroactive response to international law as women have been able to come into the space and own it, to bring those experiences to say, well, if this law is to be relevant to today's society, if it's supposed to means something. And I think we can talk a little bit about the crisis of international law and multilateralism that we're also currently facing. You have to interpret it and utilize it as a tool to respond to the needs of the current society. And so just because men who wrote these laws in the 40s didn't think of a gendered interpretation or what the gendered implications are, doesn't mean that the law shouldn't now be required to cover those exact scenarios. And I think that's a part of the history of an organization like GJC is it takes legal activism to actually bring these things to the fore. You know, our founder was someone who she came from the reproductive rights movement in the United States. She was the first head of the ACLU's Reproductive Freedom Project, founded the Center for Reproductive Rights, was somebody who used the law as a tool to advance reproductive rights. And a part of the impetus for GJC was making the connection to say that you absolutely have to make progress on issues like reproductive rights, but you also have to kind of take this larger structural approach to gender equality in the law in the first place. And so to things that, you know, Christine was talking about, from when I started, we had conversations about what is a feminist approach to the law of state responsibility, which there's not a whole lot of conversation about, but it's, you know, it's not just about Cedaw, right? It is about the structures themselves. And so those are the conversations that GJC, you know, seeks to be a part of and try to advance and push forward. And I will say that as a part of this, as a story, I think, you know, of women, as the way I like to think about it and tell it, is it's also the story of the deep discomfort of those who see themselves as protectors of the law, largely men, right? We have been accused in our work. You know, people are much more comfortable with like an academic article kind of vaguely exploring what the context of what some of this could look like. But the minute you try to actually put that into practice or shift how a state is supposed to be looking at an obligation or complying with an obligation, you get discomfort. So we've been accused, again, by prominent male academics and others in the space of doing things like abusing the law. We've been accused when we push forward on certain regimes like on IHL that if we push too far, not only are we doing a disservice to the law, but we might lose the gains that women have already made, like having sexual violence be considered a war crime. And do we really want to be taking those risks? And I find that discomfort to say we're doing the right thing. You know, I think you have to take validation in all of the places where you're creating friction. Because I think where we're making things uncomfortable for people is where we know that we're pushing on the right buttons. And so I think that to me is the ethos of GJC in this space, is melding this conversation around feminism with kind of trying to find and identify particular issues where we can actually push these things forward. And so, you know, that to me is consistently exciting. And it's, you know, I think there's still so much to go. And so for us, you know, there's places, for example, I'll talk about, you know, our work that has probably been the most controversial and upset the most number of people is trying to move and talk about reproductive rights in the context of humanitarian law. You know, Beth talked a lot about how in the context of recognizing sexual violence, and Christine mentioned this too, we've been very comfortable in some ways, though that probably understates it, in talking about the need to protect women from violence. But the minute you start talking about how do you then take the entitlements and state obligations to actively take a robust gender perspective, for example, recognizing that access to abortion and sexual and reproductive rights might be something that needs to be provided as a part of medical care. In war, you start getting into deeply uncomfortable conversations that no one wants to talk about, and they tell you to go to Cedaw. Thank you, Beth, for explaining what Cedaw is, but Cedaw is the human rights treaty that largely lays out and is focused on gender equality, elimination of discrimination. But what happens is when you pigeonhole things only to the Women's Rights Treaty, you don't actually get to all of the spaces where you need to be talking about gendered impacts. And I think that's where this next phase has to go, is we need to not just be advancing a protection narrative of women from violence. We need to not just be working as women in the spaces on issues that we are traditionally conceptualized or where it's comfortable for us to be pushed to, frankly. I don't even know that it's necessarily a choice that women are making. I think it's where we get pigeonholed to talk about these issues, but we need to be in all of the other spaces bringing these experiences. And I think, Beth, you talked about the importance of getting women in these spaces. Without a Patty Sellers in the ICTY office, we probably wouldn't be at all where we are. But I think what's also important about Patty is Patty's a deep feminist. And that also matters. We have women now, we're seeing increased representation, and that is very important. But what also makes a difference is someone like Patty is an intersectional feminist who's bringing that approach to every piece of the work that she does. And so she's not just bringing her individual experience as a woman, she's bringing a deep expertise and thinking radically about how to integrate that into the work. And I think that is the other piece that's really important, is that we don't just lay down on areas of representation, but we also make sure that when we talk about equality and gender, we're also talking about a feminist approach, and not just women talking about women's issues. Because I think we can talk about what that means, but there's a vast difference there. Maybe I'll stop there. I've just kind of been like picking up on different things that Kristina and Beth said, not necessarily in any particular order.
I'm not going to let you stop here. Akila, what is your personal story?
Oh, sorry. Very quickly. My personal story is, it's one that is both informed by my own experiences. I was born in India. My mother was widowed when she was quite young, and she decided to move to the United States on her own with 2 daughters as a matter of having a different access to opportunities for herself, as someone who was married when she was 20 and widowed when she was not even 30. And then, what opportunities does that offer for us? So for me, there's been a deep experience of what it means to exist in a society as a woman. What are the barriers that are faced by women? And that kind of combined with, the expectation that as a young Indian woman with a lot of, with relative privilege, that I was going to go to grad school. Because it was going to be a doctor, a lawyer, an engineer, was one of those 3, and I picked lawyer. But for me, it also felt it was really important that I translate these experiences into the work that I do. And so that was something that I sought out. I was always interested in international law. I had a pretty traditional education in international law that had nothing to do with feminism. But trying to find the experiences in organizations like GJC that allow you to marry being a lawyer, being a creative thinker, and feminism is kind of my own personal journey here.
Thank you so much for sharing that. This is brilliant. And I just wish that after COVID, we could all get together and have drinks and chat for many, many hours. But I actually only have the privilege of asking you more questions for another 10 minutes or so before we open to the audience. And there's so much to discuss. So I would have liked to somehow talk about women, peace and security and what it means to get those feminist demands into the Security Council. I'd also like to talk about the Istanbul Convention and especially the attacks on the Istanbul Convention and how we defend LGBTQI and women's rights that have been so under attack over the recent years. But also I'd like to hear more practical examples of, Akila, for example, your work in Myanmar. So I'm just throwing all of this in here and each of you to pick one of these areas and give us more tangible feeling of what it means to work on feminism and international law. Kristina, do you want to start?
Okay, can I make a couple of comments though? I mean, there's so much I want to say out of what Akila and Beth have both said. You say we could go on for ages. But can I just make 2 very quick points from what they said? One is they've both emphasized the importance of having women in the high places, I think Beth said, and they used the example of Patty. And I do think it's important, this actually perhaps links to women, peace and security. It is absolutely vital, as they have said, that when women are in those positions where they may be helping to make law, maybe helping to make important policy decision-making, adjudicating, etc., that they are feminists. Because I think too often institutionally, and I think this is true of the women, peace and security agenda, there is too often an assumption that it's numbers. Okay, we have so many more women in it, we've done our job. Tick the box, that's it. And that is just not the case. And they have made so strongly that that is not the case. And the second point is we've talked about international law as state-based, so that it's law as between states. And as Beth, I think it was, said, it's extended beyond that in terms of responsibility for the acts of non-state actors, in responsibilities and obligations for international organizations, for individuals, and so on. But I think we should never forget as well that while it is still state-based, of course, it is still centered around certain states, the powerful states. And it is these states that replicate the patriarchy that we see at home. And so the absolute patriarchal, militaristic, masculinized notion of international law is absolutely inherent there. And of course, it's very much a legal system that is still Eurocentered, and that was built very much to protect the interests of the powerful states over those that were not so, imperialist, colonized, and all of that history is still there. And I think an important part of feminism is exposing those biases in international law itself, so as to try, and when we're talking about equalities, it's equalities between states as well as within states, and to try and move from that colonized, neoliberal aspects that dominate it. Okay, that's probably taken up my time. I'll say a couple of words about the Istanbul Convention, because out of the ones you've raised, that's what I know best. It was the 10-year anniversary of the Istanbul Convention, the signing of the Istanbul Convention last week. And at a conference with the Council of Europe that was actually held in Germany to assess, do a stock take on the Istanbul Convention 10 years later. For those that don't know, this is the convention on preventing and combating violence against women. It's a European convention. It's primarily, well, the member states are European states, and it has been shaken recently by the the strength of the anti-gender campaign, which has led to Turkey announcing that it is going to withdraw from the convention. And this has been, it's shocking. The idea that a state can now say, we're coming out of that convention. Arguments that are used about it are that it threatens the family, that and the point that you just raised, that it encourages lesbianism, it encourages, so it's transphobic, homophobic challenges to the Istanbul Convention. And in talking about, it was the first convention, I think, relating to violence against women that overtly takes a view about gender-based violence and defines gender in treaty form. Of course, the International Criminal Court's Rome Statute also does so, but the Istanbul moves on to the notion away from biological sex, far more to gender as a construct, which was highly controversial at the time that the convention was negotiated. And it is that that has now been focused on as a means of attack. And very strongly, the view was being put last week that the only way to really challenge is to keep emphasizing the facts of violence against women, the facts of the way in which patriarchy, male domination, feed into gender stereotypes that maintain women's subordination and contributes to the violence against women. The facts about, if we want to be really instrumentalist, how much violence against women costs countries every year in addressing it. Facts about the way in which having the convention internalized into domestic law is and has changed policies within domestic law. How, and there were examples given from France, from Belgium, from a number of countries across Europe, about the way in which the Istanbul Convention has influenced healthcare policies, social care policies, education policies, media policies, and the importance of working holistically. And I think this is a message for international law generally, and it goes back to trying to move away from individual specialized regimes to see the whole and the need for comprehensive holistic approaches. And that the convention is about tackling violence against women. It is not about threatening the family. There are myths. We have to dispel those myths. We have to keep firm on message all the time. I better stop there. We're moving fast on our time.
No, that's great. And at the center, we recently published a study called Power Over Rights, where we've been investigating, like doing desk research, but also lots of interviews and roundtables, those international attacks on the Istanbul Convention, the women's rights, the LGBTQI rights regime. So thank you for bringing that up. Beth, are you happy to pick any of the topics I mentioned before and comment on the importance of feminist analysis?
Yeah, I think it's really interesting to think about international law as liberatory and as getting ahead of domestic law. And in some respects, international law falls behind domestic law, and we make more progress at the domestic level. I think for a while there was a real sense of optimism about what international law could do, because international law was, for the first time with the development of the human rights movement, speaking to, as I mentioned, how states could treat their own citizens. There was no longer a black box around a state where they could push away any scrutiny and avoid, enjoy impunity for how they were treating their own persons. And so many of us, I think, thought that international law was going to be an incredibly important tool to sidestep and to jump over the domestic law framework, which was often quite inhibitory when it came to women, sexual minorities, LGBTQI persons, etc. And in some respects, I think we've had that. But now international law, once it gets frozen in place, can then be dragging us down. And I think Cedaw is an interesting example of this. It's an incredibly important treaty. It was an incredibly important treaty in its day, and it remains so. But if you actually read the text of it now, you realize how it's a very old school approach. It was sort of men are here, women need to be brought up to here. We need to enjoy equality. That was the message of that treaty. It was not transformative at all. It did not rethink gender roles, really. It was all about adding women and ensuring that women enjoyed all of the benefits of society to the same degree that men enjoy. It wasn't liberatory to men at all. It didn't think about how men should be entitled to rethink what expectations are laid upon them, what stereotypes they're laboring under as well. And there was very little thought at all about sexual orientation or trans issues. It's invisible in this treaty. So, but that's what we're working with now. There have been a number of important authoritative interpretations of that treaty that has started to move us into a more holistic and transformative approach, but they're simply that, they're interpretive guidance. It's not the treaty itself. We don't have a treaty, for example, devoted to LGBTQI persons. Why? Because states haven't gotten together and created such a treaty. Now, we've seen interesting movement coming out of civil society, where, as we mentioned, treaties used to be created by states for states. We now have civil society actors banding together through these transnational epistemic communities who have decided that we need a treaty on X, and they've started to draft a treaty, and slowly some good states have gotten involved, and then suddenly it becomes a status exercise. And so I'm thinking about the Ottawa Treaty, the Treaty on Persons with Disabilities. Yeah. Many of these treaties came from civil society, then entered the statist realm. They took some hits, states watered down some of those provisions, but they started strong, and those treaties were able to then be promulgated. And we've seen that the importance of treaties like the Istanbul Convention are that regional bodies built upon Cedaw. And so we see some very strong treaties. Besides Istanbul, we've got an Inter-American Convention on Violence Against Women. We've got the African Rights of Women Protocol to the African Charter on Human and People's Rights. In many respects, these regional treaties went farther than the kind of parent treaty, the original treaty. And so coming up with these alternative ways to create law that can't be captured by the sort of, lowest common denominator of the General Assembly, I think is a real challenge. But civil society now is more organized than it ever has been. And that's very much coming from a grassroots and a transnational basis. It's women talking to other women around the globe. And that creates the kind of political power necessary to put these issues on an international or a multilateral agenda.
And thank you for mentioning that, Beth, because it's also the nuclear ban treaty, for example. You mentioned the landmine ban treaty, and then the current efforts on getting a preemptive ban on lethal autonomous weapon system. And all those treaties and those attempts, they've been led by feminists. And it's Jody Williams, it's Women's International League for Peace and Freedom, it's the International Campaign to Abolish Nuclear Weapons. Is exactly those that have not had the ability to work within the current system, but then found another way, as you said, like those alternative ways. Thank you for bringing that up. Akila, would you, I mean, I don't want to limit you in like what you are going to contribute, but I would be excited to hear about your work on the genocide in Myanmar.
Sure.
I lived in Myanmar in 2017, worked for UNDP when the genocide happened. So I personally am very excited about or grateful for the work that your organization has been doing. So if you would be happy to share a little bit.
I'm happy to talk about that, but I just also want to quickly reflect, I think, on this other conversation and what Beth has risen in. You know, a point of, I think, where we're at right now is this place where we're trying to bring feminist interpretations to these old laws, right? Trying to reinterpret them, reinvigorate them, make them relevant to today's society. Things like Cedaw, you know, how the general recommendations have taken it further, you know, than what's contained within the treaty itself. And that's, I think, one exercise. And then the idea about the creation of new law, the creation of new international law, how that can be transformative. And I just want to say 2 points on that. One, I think Beth really brought up the important point of the regional treaties. And I think those also help with this narrative around the context of like decolonizing international law, right? Is how are these norms being taken up and being domesticated in regional levels and domestic levels in ways that represent the needs of particularized communities, particularized regions, particularized countries. And so I think that's a really important place where we want to be thinking about it, because if you look at the Maputo Protocol in Africa, for example, that takes Cedaw and takes it much further. And it's an incredibly important baseline. And frankly, you know, when we think about it, we often think about like, well, international laws here, then you've got regional, then you've got domestic, in a way that where it all flows down. But really, how should we all be learning from the Maputo Protocol to improve international law? You know, how should Cedaw be improved by what's in the context of a regional treaty that was developed by African women? And I think that's that back and forth conversation is a really important one that we need to have. The second I will say is, in the context of the creation of new law, one area where we've been engaged is there's a draft crimes against humanity treaty that's currently on the table. And one interesting aspect of it is there's a real impetus and a desire to say we have no treaty on crimes against humanity. It's very, very important to have this treaty. But what they've essentially done is they replicated the old law. They replicated the Rome Statute. And with that, they actually brought forward with them bad gender compromises that were made in the Rome Statute straight into this and said, listen, for political convenience, we've already got this much consensus on all of the things in there. So we don't really want to touch the substance of this other than a few things that have to relate to making it not just a treaty of international criminal law, but a treaty of kind of, you know, state responsibility as well. And so what that did was it brought forward with it, for example, a regressive definition of gender, which women's civil society and LGBTQI civil society banded together to actually have removed. It continues to have this provision that makes, you know, where during the negotiation of the Rome Statute, the Catholic Church was heavily involved. And so there's this caveat on the crime of forced pregnancy, just a footnote that doesn't exist for any other crime, that says that this has nothing to do with national policies on abortion. Why? And now we're carrying that forward, right? So there's also this need to investigate these processes to make sure that we're not just replicating the exact conversation, sometimes for political convenience, because as Beth said, it's difficult to get things passed through the General Assembly. But, you know, I think there's a need for feminists to exist in all of these spaces to be able to pick up on all of these things and make it difficult and say that just because it's convenient doesn't mean we should replicate negative gender experiences from previous treaties. And so that's something that we're working on as well. And I think is important as we think about the creation is in, on the one hand, where creation is kind of more from the ground up, led by feminists, you might get better things. You can also think about, you know, gendered language that made it into the Arms Trade Treaty is another example. But then, you know, you have kind of all of these different dynamics that are at play. So I just wanted to kind of reflect on that, because I think that's an important piece of where we're at, and also how civil society, academics, and others can engage in these feminist analysis and push these things forward. And then quickly on Myanmar, I guess there's so much to say about Myanmar right now. Myanmar is probably, it's just an interesting case of international law and the failure of international law in some ways to think about. And, you know, one area where, as you mentioned, we've been very engaged is around the genocide of the Rohingya. And so our work we've spent a lot of time focusing on how gender could be understood in not only the commission of the genocide, which is very important in terms of the specific crimes of genocide itself and how gender informs that, but we've also been really interested in utilizing this to make the case for how states failed in their duties to prevent and punish genocide, and how that has a gendered lens and a gendered perspective. So thinking about this tension where we've talked about the comfort in acknowledging individual crimes, right? So yes, somebody committed a gendered crime. We're comfortable putting an individual on the hook, but we're less comfortable with saying a state failed in its entire responsibility to prevent genocide by allowing policies that were gender discriminatory, for example. And that's somewhere we're really interested, is that this has to do with this context of trying to bring a feminist perspective to the relations between states themselves. And the kind of the fundamental pieces that construct this area of law. And so that for us has been a really important part of this project, is to translate this commitment to recognizing sexual and gender-based violence, which, you know, and that recognition, by the way, also the work of feminist jurists. It was the work of women's civil society in Rwanda who got this issue pushed up. It was the role of a team of legal advisors working behind the scenes at the Rwanda tribunal, Navi Pillay as a judge at the tribunal, helping to bring forward this recognition in the first place, because that was a law that wasn't gendered. And now building on that and thinking about how do we take this political buy-in around protection issues for women into seeing if we can help fundamentally understand state failures. Because I think this also goes back a little bit to Christine's point on the Istanbul Convention. You know, we're more comfortable talking about individual instances of violence, but when you say a state has responsibility, like when violence is happening in the home, for example, and we say that a state is failing in its responsibility to do something about it, that's where everyone gets triggered. That's where you start seeing the reactions, right? It's the connection of the individual gendered experiences to the systems of patriarchy and trying to dismantle the systems themselves. And I think that is the big, like the next, you know, the big challenge is to move from the individual to the systems. And that is the project of feminists for a very long time. And I think there's a specific challenge here in the law to do so.
Okay. I am a bit sorry to the audience because there's not much time left, but it's just been way too interesting, everything so far. Let me try to find a couple of short questions, maybe. Akila, you mentioned the regional treaties as a way of decolonizing international law. There is a question on exactly that law, international law, has not only been shaped by states and their representatives, but by Western states, right? What the panel mentioned before as well. Can you give other examples of how we can decolonize international law?
I can take a start. I mean, I think that's one of the most important areas that we need to be talking about right now. And I think sometimes this conversation has become overly simplified, if I'm being honest, right? There's this kind of, and we get this particularly in gender, is states almost use it as a cudgel against international law. You know, they'll say, well, this is developed by Western states. And we work with, you know, women around the world who look to international law as a place of inspiration for the work that they're trying to do and as an important tool. And so I think it's important to also, in this context, not fall under that trap as well, just because I think it's a really convenient argument for states like Myanmar, who constantly say, well, why aren't you doing this? I think another place where we've really been doing a lot of thinking in the decolonization context is to also spend a lot more time thinking about how to hold and translate the commitments under international law for states like the United States or others who are very involved in the conversation on this is for the other, human rights is for the other, and human rights is not for us. And so the importance to say that this is equally applicable to everybody within the system. And that means, United States not having ratified Cedaw is a problem, not because the way that often it's phrased in the US is because it undermines our global leadership on gender equality, but because it actually, one, shows a certain level of hypocrisy around our own commitments to this system that's not for the other, but it also then shortchanges women here in the United States of a more progressive framework for their own rights. And so to think about how to also spend as much energy and time holding, I'll just say like states that are easier to be held accountable, right? The traditional subjects of international law, while they're the states that make the law and they themselves haven't been held to account. So I think that's another important space that we need to spend more time on to create a more equal kind of playing field when it comes to the framework.
Thank you, Akila. Beth, there is a question on the military from a listener from the Philippines. I'd like to slightly change the question a little bit and make it a bit broader because of your experience and expertise and the positions you've held. You have a lot of expertise on war crimes. So hence why asking the question about militarization. There has been a lot of feminist engagement with international law on weapons and the proliferation of weapons, most famously the Arms Trade Treaty and the provision on sexualized violence and gender-based violence. Can you give us, I don't know, an idea or the latest challenges of feminist engagements in the realm of militarization or where we're at?
Mm-hmm. Yeah, I think there's a lot of thinking being done, and I know your center has done some of as well in terms of demilitarizing foreign policy, that we always think we want to use the most strong and robust measures, and that inevitably takes us to, the Pentagon rather than the State Department or the Development Agency. And so thinking about foreign policy along this continuum, I think is going to be a real challenge to the Biden administration and other administrations going forward. But we have to remember, we call the laws of armed conflict, well, some segments of people who use this law call it international humanitarian law. And the goal is to emphasize that humanitarian aspect of it. Military people call it the law of armed conflict, LOAC. They're talking about the same body of law, but they can't even agree on what to call it. And part of that is because the law of armed conflict, while those of us who come at it from more of a human rights perspective, perhaps, or a concern about civilian protection perspective, want to emphasize the humanitarian aspects of it, it's still quite tolerant of violence. It's still quite tolerant of resorting to arms. It's trying to regulate the use of arms and to make certain persons and objects inviolable and to protect them. But ultimately, it's accepting the fact that we've used military violence to try and solve a dispute. Now, I'm not here to say that that's not often the case. There is a time and a place for the use of kinetic force, and I think everyone would agree to that. But are we overusing that tool in certain environments? And so, it's unlawful to directly target civilians. That everyone agrees on. But when you're targeting a building, for example, where there is a military objective there, there's an appropriate target there, but it's embedded within a civilian environment, which is housing women and children, vulnerable persons, non-combatants, etc. What level of force are you entitled as a combatant to use vis-a-vis that appropriate military target? That's where we're fighting about now, because the target is appropriate. The question is what level of proportionality, and many different people will approach that balance between looking at the military objective and saying that's a valid military objective, but then saying what level of force are we allowed to use and what sort of precautions do we have to put into place in order to protect the civilian population? Many different people will come at that question from different perspectives. And so a feminist approach would want to think about how to rethink proportionality and to make sure that the civilian interests are protected and they're given due weight in terms of what level of force is using. And then thinking about, are there other ways to solve or to achieve this, whatever the military end happens to be, that doesn't require using strong amounts of kinetic force in an urban environment where there are, civilian population located. That's an area where I think we haven't done enough thinking about. There have been some really great articles on trying to rethink proportionality and even rethink whether or not we should have a regime that says it's okay to kill rather than capture. If a state has the ability to neutralize an opponent, must they, or are they entitled to always kill that person? Or is there an argument that says you should use a lesser form of force? That's another area where we have a lot of good thinking at the theoretical level, but it hasn't permeated the operational level or the sort of positive law of LOAC or IHL, depending on which perspective you're taking.
The final question will be for you, Christine. We started with you, and the final question will be for you as well. I can't believe the hour is already over. This has just been pure brilliance and excellence, and I'm so grateful for the work all of you have been doing for years and decades. You've made this world like such a much better place. Christine, if you like it or not, at least by this panel and by many more, you are recognized as one of the trailblazers in feminist approaches to international law. Christine, what are you currently mainly working on, and what are the most urgent challenges ahead in the short term, and what do we have to tackle in the long term?
What I'm working on at the moment is a project called the Feminist International Law of Peace. And what we are trying to do through this project is to think about, well, what would peace look like? And to me, that is also, we only have to look at what's going on in the world today. I mean, the news that's coming out of Israel and Gaza, we've talked about Myanmar, the withdrawal from Afghanistan and the concerns about what is going to happen. We could go on, and both Beth and Akila are working in so many of those areas. So what really would constitute a feminist peace? That is a peace that is not supported solely through militarized lines. It is more than the sum of individual peace processes. And I think it's just really interesting that international law, in fact, does not define peace. And the whole notion of international law essentially is that there is war and everything else is peace. For women, that simply is not true. And women's lives in so many ways are not peaceful, even when they don't live in what is traditionally regarded as a war zone. And so we're trying to look at all the multiple ways in which a feminist peace might be constructed. I'd say this is both the short term and certainly long term. We're not going to resolve this certainly anytime soon. And we, one of the things that we do, I think perhaps two things just to finish off with. One is the importance in doing this in seeing law along with other disciplines. So we've been looking at arts, literature, poetry, multiple other ways in which people have conceived of, presented their vision of what constitutes peace, song, music. And so law is, yes, it's a tool, but there are multiple other tools for conceptualizing and understanding particular situations. And the other, just to finish on, we have got on our website, this is the website for the Center of Women, Peace and Security, what we called a vision of feminist peace. And it's in the form of a letter written to the member states of the United Nations on the 75th anniversary of the United Nations. And it sets out in 12 paragraphs things that we would like them to take on board in thinking about peace. Give you a couple of examples. Why is it called a Security Council? Why is it not a Peace Council? Why is it the Security Council that is at the sort of apex of the United Nations system? Many of the things that are in it we've talked about today: the importance of human rights, the importance of disarmament, the importance of eradicating patriarchy, misogyny, colonial domination, totalitarian, I can't even say it, ism, and really importantly as well, looking at the way in which the challenges to the environment are an absolute major threat to the peace, and how feminist thinking, drawing again on cultures emanating, for example, from Indigenous persons, weaving those in to approaches to addressing the challenge of the environment. If we don't do that, there cannot be a peace, a feminist peace, and I think international law would therefore become irrelevant.
Yes, thank
Please
you.
look at our letter.
Can you share it here? Do you have a link for us?
Oh gosh, I'm hopeless at finding links quickly.
If not,
Can I
we'll
send it
share
you?
it. You send it
send
to
it you.
us.
Yeah,
And
I'll send it to
everyone
you.
who's interested, please look at our Twitter and Instagram over the next day, because we'll be sharing it there. Christine, Beth, Akila, thank you again so much, not only for this hour that you took out of your busy schedule to be here now, but also generally for the work that you have been doing. Our organization, the Center for Feminist Foreign Policy, would simply not exist without the trailblazers and giants that you and other feminists are, on whose shoulders we are standing. So we are extremely grateful. That is now a wrap. Thank you. If anyone listening would be interested in supporting and joining our work at the Center a bit more, please join the membership program that Antonia just now pasted here in the chat. And I wish everyone a wonderful evening, day, depending on where you are. And we'll be back and we'll continue this conversation. Thank you so much.
And can we say thank you as well?
Thank you. Yes.
Thank
It's
you.
been
Thank you for
wonderful being
convening
there.
us. Let's
And Akila,
continue the
thanks for the link.
conversation.
Thanks
No
for
problem.